Respected viewers, today I am going to talk about a recent judgment of the Supreme Court, which has been pronounced on 5th January 2023. In extraordinary appellate jurisdiction of the Honorable Supreme Court in case Rohan, Dhungat, etc., petitioners versus the state of Goa and others. In this case, all the petitioners were convicts and they applied for premature release under the rules. The State Sentence Revenue Board recommended for premature release of the convicts. The state government sought the opinion of the convicting court on the premature release of the petitioners. The convicting court opined that the convicts shall not be released prematurely considering the gravity of the offense. Therefore, the state government rejected the premature release of the petitioners. The petitioners were aggrieved with the decision of the state government and they preferred petitions before the High Court of Bombay, challenging the decision of the state, not considering their premature release. Before the High Court, the petitioner's pleading was that they have completed 14 years in the custody, therefore, as such, they were entitled for the premature release. They further stated that the period of parole has been excluded in commutation of their sentence, which should not be excluded. And considering the parole period as a sentence, their actual period of imprisonment has been completed and they are entitled for the premature release. The Bombay High Court held that the period of parole is to be excluded from the period of sentence while considering the 14 years of the actual imprisonment period for the purposes of premature release, as the respective convicts have not completed 14 years excluding the period of parole of actual imprisonment. Therefore, they are not entitled for the release and the writ petitions were dismissed. The plea of the convicts before the High Court was that even while on parole, they can said to be in the custody and therefore the period of parole has to be included while considering 14 years of the actual imprisonment for the purpose of premature release. They submitted that even as per section 55 of the Prisons Act, a prison a prisoner when being taken to or from any prison in which he may be lawfully confined shall be deemed to be in prison and therefore deemed to be in custody, and therefore the period of parole shall have to be included as a period of custody for the purpose of actual period of imprisonment while considering 14 years of actual imprisonment. The Honorable Supreme Court held that if the submission on behalf of the prisoners that the period of parole is to be included while considering 14 years of actual imprisonment is accepted. In that case, any prisoner who may be influential may get the parole for number of times as there is no restriction and it can be granted number of times, and if the submission on behalf of the prisoners is accepted, it may defeat the very object and purpose of actual imprisonment. Therefore, the Supreme Court was of the firm view that for the purpose of considering actual imprisonment, the period of parole is to be excluded, and the Honorable Supreme Court was in complete agreement with the view taken by the High Court of Bombay. In view of this, the special leave petition was dismissed by the Honorable Supreme Court. Thank you very much.